Can a proclamation of emergency be made during the continuance of another emergency proclaimed earlier? Which Indian state had the longest tenure of president's rule? What is the total number of times president's rules has been imposed in Manipur? Which Indian state has never experienced president's rules so far? What are the circumstances in which a proclamation of emergency can be made under the constitutions of India? You are watching easy learning site Mr. Ask Me Anything. Dear friends, in this video series I am going to simplify part 18 of Indian Constitution, that is the provisions of emergency. The Indian Constitution provides three types of emergencies, each under different circumstances. They are National Emergency under Article 352, State Emergency, that is also President's Rules under Article 356, Financial Emergency under Article 360 of the Indian Constitution. Let me come to National Emergency, Article under 352 of the Indian Constitution. A national emergency can be proclaimed by the President of India if he or she is satisfied that the security of India or any part of its territory is threatened by war, external aggression, armed rebellion. Now this armed rebellion is replaced from internal disturbance by the 44th Amendment of 1978. Here, war involves a formal declaration of conflict between nations, while external aggression is a unilateral attack without a formal declaration. Let us come to the example. In the year 1962, there was Indo-China War, which was national emergency due to external aggression. In the year 1971, there was Indo-Pak War, which is also a national emergency due to external aggression. The most controversial emergency, that is the emergency of 1975, declared on the grounds of internal disturbance, is criticized severely at the latter period. Let us come to the procedure of proclamation of national emergency under Article 352. First point, the President can proclaim an emergency only on the basis of written request by the cabinet headed by the Prime Minister, not just the Prime Minister. Second point, proclamation must be approved by both houses of Parliament within 1 month from the date of its proclamation. The third point is, once approved, it continues for 6 months and can be renewed indefinitely with Parliament's approval every 6 months. A resolution approving the proclamation must be passed by the special majority, that is by a majority of a total numbers of each house and also by a majority of not less than 2/3 of the members present and voting in each house. Prior to the 44th Amendment Act 1978, such resolutions could be passed by Parliament by a simple majority. A proclamation of emergency can be revoked by the President at any time by a subsequent proclamation. Such a proclamation does not require parliamentary approval. The 44th Constitutional Amendment Act 1978 mandated that the President must revoke a proclamation of national emergency if the Lok Sabha passes a resolution disapproving its continuation. Now let us come to the second type of the emergency, that is President rules or state emergency or constitutional emergency under Article 356 of the Indian Constitution. It is proclaimed when the President is satisfied that the government of a state cannot be carried on in accordance with the provisions of the constitutions, maybe because of either of the following reason. Number 1, hung assembly, no majority party. Number 2, defection, loss of majority. Number 3, breakdown of law and order. The fourth point, failure to comply with constitutional directions. President rule is generally declared when the governor of the state sends a report to the president stating that the state government is not functioning according to the constitution. Now let us come to the procedure. First point, proclamation must be approved by both houses of Parliament within 2 months. The second point is, if the proclamation is approved by both houses of Parliament, then it continues for 6 months from the date of proclamation, otherwise expires in 2 months. Let us come to the third point. Proclamation can be extended up to 3 years. Here, beyond 1 year, only if a national emergency is enforced or election commission certifies that election cannot be held. However, the proclamation may be extended for the period of 6 months at a time. Example, Manipur has seen multiple instances of president's rules due to political instability. It is the 11th president rule imposed on 13 February 2025. Punjab has the longest spell of president rule due to terrorism. Now let us come to the third type of emergency, that is financial emergency given under Article 360 of the Indian Constitution. When the President is satisfied that the financial stability or a credit of India or any part of the territory of India is threatened, he or she may proclaim financial emergency. During financial emergency, Centre can give directions to states on financial financial matters. Salaries of government officials including judges can be reduced. Money bills of the state legislature can be reserved for the president. Let us come to the procedure. First point, proclamation of financial emergency must be approved by both houses of the parliament within 2 months. Second point, once the proclamation of financial emergency is approved, it continues indefinitely until revoked. However, no financial emergency has been declared in India till then. All the 3 types of proclamations of emergency can be revoked by the president at any time by a subsequent proclamation and does not require the approval of the parliament. Now let us try to come to the answer for those technical questions like can more than one emergency be enforced at the same time? The answer is yes. There is no constitutional restriction on proclaiming one type of emergency during the continuance of another. Example, a president rule can operate in a state while the country is under national emergency. A financial emergency can be proclaimed even if other emergencies are already in force. Now let us try to look to the constitutional provisions involved in different emergencies. Article 352 talks about national emergency. Article 356 give a provisions of president's rules or state emergency or constitutional emergency. Article 360 contain the provisions of financial emergency. Now let us come to the 44th Constitutional Amendment Act 1978. This Constitutional Amendment Act 1978, that is 44th Constitutional Amendment Act 1978, brought safeguards against misuse. For example, it replaced internal disturbance with armed rebellion and also required written advice of the cabinet. It also protected Articles 20 and 21 during emergency and so on. So let us come to the conclusion now. The emergency provisions in the constitutions are extraordinary powers meant to safeguard the integrity and functioning of the country during crisis. However, their misuse can seriously affect democracy, federalism and individual freedoms as seen during the 1975 emergency. India has learned from its history and the 44th Amendment has added constitutional checks to prevent arbitrary or politically motivated proclamation. Yet, understanding the circumstances, procedures and implication of emergency is crucial for every law student, civil servant and citizens. Thus we come to know there is no constitutional restriction on proclaiming one type of emergency during the continuance of another. Punjab had the longest continuous spell of president's rules lasting 5 years due to insurgency and terrorism. As of July 2025, President's rules has been imposed 11 times in Manipur, reflecting its history of political instability. Chhattisgarh and Telangana have never faced President's rule as of July 2025. Thank you for watching Mr. Ask Me Anything. Please do like, share, comment and subscribe. For this video, I am signing out. Till then, take care.